Good afternoon, everyone. Thank you for joining us today. In today's webinar, we have invited Ms. Whitney Drake from American Gateways for a session on immigration relief for Asian hate crime victims and remedies available as a response to a surge in hate crime against Asians in the US. We will be recording this presentation. Just a minute, let me share my screen with everybody. My bad. Yeah, so we will be recording this webinar. At the end of the presentation, there will be an opportunity for Q&A. If you have any questions, please feel free to leave your questions in the Q&A section below. We would also like to thank our corporate partners for their continuous support. Now I would like to hand it over to Ms. Fang Fang. She's our president and CEO. Fang Fang.
Thanks, Moing. Good afternoon, everyone. Thank you for taking your time off on the weekend to be here with us. My name is Fang Fang, and I'm the president and the CEO of the Greater Austin Asian Chamber of Commerce. Our chamber is the leading partner for driving local economic growth for businesses with ties to Asia and Asian Americans here in Austin. We're very pleased today to partner with American Gateway to host today's workshop as part of our Asian Pacific American Heritage Month event series. Please give a warm welcome to Whitney Drake. Whitney is an attorney with the Austin office of American Gateways, one of the largest immigration nonprofit legal services provider in Texas. Following law school, Whitney served as a law clerk for Judge Priscilla R. Owen of the U.S. Court of Appeals for the Fifth Circuit, and then as a legal fellow at the Advocates for Human Rights in Minneapolis, funded by a Texas Law Julius Glickman Fellowship in Public Interest Law. At Texas Law, Whitney served as executive editor of the Texas International Law Journal and participated in Immigration Clinic and Actual Innocence Clinic. Whitney is bilingual in English and in Spanish. I wanted to point that out so that people know that she can help in many fronts with folks with a language barrier. Welcome again, Whitney, and without further delay, let me hand it over to you right now.
Thank you so much. We're so happy to be here. Very thankful to the Greater Austin Asian Chamber of Commerce for welcoming us today to present. So I will share my screen with you all. Okay, so as mentioned, we'll be talking about immigration relief for victims of hate crime. So that is principally the U visa. So we will be talking about today who qualifies for that, what is the process to apply, and go over some of the requirements. So a little bit about American Gateways. We are a nonprofit organization with offices in San Antonio, Waco, and Austin. We were founded in 1987, and we started as the Political Asylum Project of Austin, focusing on asylum claims within the United States, and have since branched out to many other areas of immigration law, but focusing on trauma survivors. So we provide free and low-cost immigration legal services. So that's direct representation to Central Texans in need of our services. We also provide services at 3 immigration detention centers in Central Texas. Our service area incorporates 23 counties in the Central Texas area. We provide services in 3 main fields. First, what we'll be focusing on today, survivors of violence and human trafficking. We also provide services to those fleeing violence in their countries of origin and who are applying for asylum in the United States, and to those individuals in detention. As I mentioned, we provide services at 3 local detention centers. We also provide assistance in family petitions, so a US citizen or a lawful permanent resident, a green card holder who is applying for a family member who's already in the United States or abroad and wants to join them in the United States. And we also assist those green card holders or lawful permanent residents with applying for citizenship in the United States as well. So why discuss the U visa at all? So this will be no surprise to our attendees today, but due to the increase in crimes and discrimination in against Asian Americans during the pandemic, unfortunately, it's an apropos topic to be discussing at this time. So I have two links here that I believe will be shared with you in the chat if you'd like a little bit more in-depth information on what is happening within the United States and on a worldwide scale. So what is the U visa? The U visa is an application for immigrant status in the United States, for technically called non-immigrant status. So it's created to help those who were victims of crime in the United States. The idea is that they wanted to encourage individuals to report crimes committed against them and provide them protection against deportation so that they were able to assist in the investigation or the prosecution of that crime. So who qualifies? Immigrants who are the victims of certain crimes, we'll talk about which crimes qualify in a minute. The crime must have occurred in the United States. So this is something that comes up every now and then, especially, people may have been victims of crime in their home country or victims of crime on their way to the United States. And those things may be relevant for other forms of immigration relief, such as a human trafficking, T visa, or asylum for people fleeing violence in their country of origin. The U visa, though, specifically focuses on those crimes that occurred in the United States. And when you're thinking about the reason why the U visa was created, this makes sense because the idea is that, immigration and Congress wanted people to feel comfortable to be able to come forward, report crimes that were committed against them without fear of deportation or negative immigration consequences for reporting that crime. So the first thing to establish is that the crime occurred within the United States. Second, the victim has to help during the investigation or the prosecution of the crime. And so the or there is really important because, not every crime that is investigated will go to prosecution. Sometimes you cannot find the individuals who perpetrated the crime, or for whatever reason, they don't prosecute the crime. So it's not necessary that the district attorney or county attorney where the crime occurred prosecutes the crime. It's enough to report it to the proper authorities. So that could be the police, that could be Homeland Security investigations, it could be a federal authority, but the crime does need to be reported. And the person who was the victim of the crime needs to be cooperative with all quote unquote reasonable requests for cooperation. So being helpful during the investigation or participating in the investigation of the crime is an important component. The crime also has to cause considerable or serious physical or mental harm. And this can be showed in with a lot of different types of evidence. In a lot of U visa cases, unfortunately, there is a combination of physical and mental harm. So we will use things like hospital records. The police report will sometimes detail physical harm, photographs of the individual after the crime. And then for mental or psychological harm, oftentimes we are working with an expert in that field, be it a psychotherapist or a psychiatrist diagnosis, to better describe the psychological consequences of being a victim of a crime. So those can be things like post-traumatic stress disorder or anxiety following the commission of the crime. So that's the third requirement, is showing that you suffered physical or mental harm. And then a qualifying official So someone with law enforcement must issue a certification stating that the victim helped the police or whatever, agency was doing the investigation, or the prosecutor with the case is still helping or will help at some point. So this is the interesting part about the U visa. It actually requires the participation of our law enforcement authorities, be it a judge, a police officer, a prosecutor. They need to participate in this case. And we'll talk a little bit more about what the U visa certification process is, but it's important to sort of keep in mind that this is really a collaborative effort. So for people that live in jurisdictions that are not very immigrant friendly, this can be the starting and stopping point for them for the U visa, because it does require the authorities to participate in the process and sign a certification. So as you'll see on the screen, there are a lot of different crimes that qualify or can serve as like the foundation for a U visa. So one of the first things that I do when I'm meeting with a potential client is I need to know what crime they were a victim of, and only certain crimes qualify. So as you can see on this list, we're generally talking about very serious crimes. Most of them involve physical harm to a certain degree, but not all of them. The vast majority of the clients that we have at American Gateways fall within a few categories of being a victim of family violence, felonious assault, or sexual assault. That's the majority of the clients that I'm working with. But that being said, there's a lot of different crimes that qualify. In addition, you may be aware of someone who was nearly a victim of one of these crimes, or someone attempted to commit one of these crimes against someone. And so an attempt or a conspiracy to commit one of these crimes also qualifies. So it doesn't, it's not necessary that the crime have been carried through fully if there was an attempt to commit. So one of the most obvious ones is an attempted murder. So sometimes those are considered a felonious assault, sometimes they're considered an attempted murder, but all of, that kind of serious level of crime counts. So for purposes of talking about hate crimes, we'll talk a little bit more about felonious assault, because that is most likely to be the analogous crime for what we're focusing on today, which is hate crimes. So we'll talk about what that means in the context of Texas law. So in Texas, a felony assault or felonious assault is an assault that causes serious bodily injury or an assault that involves a deadly weapon. So as you can see here, on the list prior, right, a hate crime is not a separate qualifying crime, but a hate crime victim or their attorney or advocate can speak to law enforcement about certifying that they were a victim of a different kind of crime that does qualify. So for example, an obvious one would be felonious assault, like we've been talking about, even if the prosecutor or the police report says that they were a victim of a hate crime, which in my line of work is pretty rare, to be honest. Most of the time, even if there is a hate crime component, at least in Texas, we're generally seeing, the police report wouldn't include that element. It would be a police report for a felonious assault, for example. So if you, come into contact with someone who is a victim of a hate crime, that doesn't mean they're not going to qualify for the visa, just the opposite. The underlying facts matter a lot, and what law enforcement is willing to certify for. So this is just something to keep in mind. It could also be, like we previously mentioned, a sexual assault could qualify. So it'll just depend on the facts of what happened to that individual and what sort of crime it could fit within, because that list of crimes, that is stable right now. There's no way of changing that for the moment. So If you come into contact with someone who's been a victim of a crime, it's something, you know, what the police report says the crime was doesn't necessarily mean that's the only thing that law enforcement could certify for. Okay, so how does the U visa work? So a U visa is an administrative case. So what that means, you know, in immigration law, there's basically two kinds of applications. There are affirmative applications where an individual comes forward on their own volition and asks the US government for a visa or some kind of protection like asylum. And then there's also defensive applications, and those are made within the context of immigration court proceedings. So those are situations where the US government has decided that an individual has violated US immigration law. They have put them into removal proceedings, or colloquially called deportation proceedings. And an individual then is forced to apply for a remedy or a form of relief before the immigration court. So U visas are part of that subset where they are an affirmative application. A U visa applicant may at the same time be in removal proceedings, but the immigration judge has no authority over that application. The only agency that can adjudicate a U visa application is US Citizenship and Immigration Services. Specifically, U visas are adjudicated at the Vermont Service Center and the Nebraska Service Center. That doesn't really matter at all for purposes of our discussion, but these are applications that are filed with an agency here in the United States, adjudicated at those two service centers. So like I mentioned, this doesn't require going before an immigration judge. It does not require an interview. It's a completely paper process, and immigration law, unfortunately, is basically 90% still all paper, meaning you can't submit this application online. It has to be mailed into US Citizenship and Immigration Services, and no interview is required. So typically what we include in a U visa application is a lot of information. So there is an immigration application. There is the U visa application itself, which is the form I-918. And that includes a lot of personal biographic information and immigration history information. There's also a screening for criminal history and admissibility to the United States. There's a certain set of laws that apply to individuals requesting a non-immigrant visa or requesting a green card in the United States, and those are called admissibility laws, essentially. So you're required to show you are not inadmissible, that you are admissible to the United States. So there's a lot of different screening questions, very diverse set of questions, from, you know, past participation in prostitution to ties to terrorism. It really runs the gamut. There's a lot of information that they request of these people ahead of time. So the first part is preparing those applications. Unfortunately, they're only available in English. You have to turn them in English. You can, of course, have an attorney and an interpreter work with you on those applications, and you're certainly encouraged to do so. I think they're very difficult. It's a very difficult process to go it alone. But the applications are available online at the uscis.gov website, and the application for the U visa itself is free. There are some other ancillary applications that are generally required to include with your application. So if you're working with an individual who has a reason that makes them inadmissible to the United States, then there's a waiver form that they can file with their U visa application, asking the government to essentially forgive the past violation of immigration law. And then there's also a work permit application. We'll talk about that a little bit more in a second. So at least one application that they'll be filing, normally a total of 3 immigration applications. They'll also include a statement about their experience as a victim, how they helped the police or the prosecutor or the judge, whoever signed the certification in their case, and how the crime affected them. So this is a really, really difficult part of the case, as you can imagine. So people will have undergone a very traumatic experience generally. And unfortunately, part of the process is explaining exactly what it was like and how it has affected them. So we work with individuals and often a psychotherapist as well in preparing the statement to make sure we're doing it in a way that doesn't cause unnecessary additional trauma to the survivor. But they usually put together a fairly detailed statement discussing what happened to them and their experiences helping the authorities. They also need to provide documentation to show quote unquote good moral character and documentation of the harm they suffered. So the U visa, similar to nearly every other form of immigration relief, is discretionary. So that means that the US government is making a judgment call. It's possible that someone could meet all of the requirements for the U visa and have been a victim of a very serious crime, but the US government doesn't think they deserve the U visa, and as a matter of discretion, denies the U visa. So something that you put together are proof of ties to the community. You know, does someone have family in the United States? Are they involved in a church or a local organization that relies on them? Are there children in school and they're involved in the children's schoolwork, or, you know, who relies on them in the United States? Other proof of good moral character can be, ties to the community is one, you know, criminal history. If there is criminal history, there are ways to, you know, show rehabilitation, show that they've changed since that criminal history. And like I mentioned previously, the harm that someone suffered is usually through hospital records. But that personal statement is really important as well, because not every crime will necessitate a trip to the hospital, right? So personal statements about the harm that someone suffered can be sufficient on their own. But also, like I mentioned, you know, any medical records, a letter from a psychotherapist talking about psychological harm is helpful. Sometimes clients have photographs of the injuries or the aftermath of a crime, things like that. Very rarely the clients I have will have actual news reports about the crime, but occasionally they will make the news, and those are also things that I include just to bolster the credibility. Okay, so applying for the application, a little bit more in depth here. So in an application for a U visa, you must include a signed law enforcement certification. So like I mentioned, this is a document usually prepared by an attorney, but sometimes it can be prepared by the law enforcement agency themselves. It doesn't matter. It's really the preference of the law enforcement agency. But it's going to be signed by generally the police or the sheriff, the judge, the prosecutor, whoever is involved in the case and is willing to sign the certification. And it confirms that the victim assisted with the case. So like I mentioned, this can be the starting and stopping point for many people. So it's not the case that law enforcement is required by federal law to consider signing a certification and to sign a certification if someone appears to qualify. It's not the case at all. It is a completely discretionary decision. So as you can imagine, in Travis County, they participate in this program and consider requests for U visa certification and sign requests for U visa certification, but that is not necessarily the case in, you know, for our Waco office, for example. So not every county fully participates. So in terms of, you know, advocacy to do on a local level, this is something that we're often thinking about because some of it is just education, right, to law enforcement about what the U visa is. A law enforcement certification does not mean that law enforcement is certifying that this person deserves a visa or even qualifies for a visa. It's just certifying that this person was a victim of this crime on this date. And they have helped us with the investigation. It is then up to the U.S. Citizenship and Immigration Services agency to make all of the other decisions about that person's immigration status. So that's a common misconception sometimes among law enforcement, that the U visa is actually kind of, the certification in some way giving someone immigration status, and it does not in any way do that. It only allows them, it's kind of the first step, opening the door to being able to apply for the U visa. Without that certification, you cannot move forward with one of these cases. So it really, unfortunately, is a little bit of a lottery in some sense, because if you live in a jurisdiction that doesn't sign these forms, you could be out of luck, right? And you wouldn't be able to move forward with this case. So that's a really tricky part. The certification itself is valid for only 6 months after signing. So if you're working with a U visa victim, the crime may have occurred 3 years ago. That's no problem, as long as the certification itself was signed within the past 6 months. And the U visa applicant is required to submit their U visa packet, their U visa application packet to U.S. Citizenship and Immigration Services within 6 months while that certification is still valid. So as long as the application is submitted within those 6 months, it's considered on time. So, and then we already talked a little bit about, yeah, they're not required to sign the certification. So, and every policy or every agency, even within Austin, has different, even within, Williamson County versus Travis County, there are differences. And so working with, I encourage everyone who can work with an attorney on these applications to do so, because, some agencies will only certify a crime if it's currently pending. So then you really got to pick up the pace, right? And ask for certification as quickly as possible, because you don't know if the case will plea out, for example, or they'll close the investigation. So I think it's a good idea to work with someone in the area where you're living who is skilled and kind of knows the lay of the land, because it's not consistent among agencies in any way, shape, or form. So that's a really tricky part of one of these cases. Okay, so what does the U visa do for you? So if you have an approved U visa application, you receive legal status in the United States for 4 years. You can also receive work authorization for that same 4-year period. And work authorization is not the same as residency. Work authorization is a separate, it's a red card, not a green card, given to individuals that indicates that they are authorized to work in the United States. You can then get a social security number. In Texas, you can get a driver's license or a state ID. It does not qualify you for public benefits, generally speaking, but you are able to get your social security number and a driver's license, which makes a huge difference for people. You're protected from deportation as long as you remain in valid U visa status. And then you're eligible to apply for residency, the green card, after 3 years with the U visa. And if you fail to apply for residency and your U visa expires, you are back to being undocumented unless you have some other form of immigration relief. So the vast majority of people will apply for residency after 3 years with the U visa and hopefully receive their residency. Once they are a lawful permanent resident of the United States, in most cases, it will be a 5-year wait. So 5 years with their green card in order to apply for citizenship. So from my point of view, one of the hugest benefits of the U visa is it is a path to citizenship by giving you an ability to apply for a green card after 3 years with the U visa. And then once you have residency, generally speaking, there are some exceptions, but it's a 5-year waiting period to then apply for citizenship. And sometimes I've had a lot of questions, like to what extent is the government checking the background of these individuals? And it's checking the background of these individuals at various stages multiple times. So when you apply for a U visa, you have a fingerprint appointment, which we'll talk about a little bit on the next slide. I'll just go there, I guess. So there are multiple stages to this and multiple background checks that happen as it's going on. So the first thing to keep in mind is the U visa is one of the longest case processing times of any visa with the exception of some, if you're a brother or sister of a US citizen, but you are from Mexico, the wait times are, even longer, but this is one of the longest wait times in immigration. So you submit your application, what happens next? After 1 to 2 months, assuming that, everything was signed correctly in your application, you included the right fees, the right applications, you will receive notification from US Citizenship and Immigration Services that they received your application. This will give you a receipt number, and for a U visa, it is confidential. So you're actually not able to use your U visa receipt to check the status of your case online, which you can imagine is incredibly frustrating for U visa applicants, but the confidentiality outweighs that concern. So that receipt notice does, of course, show the date that they applied, and they are officially, quote unquote, in line for the U visa. And it's a very long process indeed. So after 2 to 3 months of submitting that application, you will, the client will receive an appointment to have their fingerprints taken. So if they apply in the Austin area, there is a immigration application support center in Austin, where you would go at a certain date and time, have your photograph taken, your fingerprints taken, and that is run through a national background check. So that's one of and then they keep those fingerprints on file. So as this process really takes a long time, they do run the fingerprints at multiple stages through the process to make sure that they have up-to-date biometrics information. So the government is definitely running people through a really rigorous background check as part of this process. So then there's a very, very long wait period. And it is so long that most of my clients think I must be joking, but unfortunately, this is the reality right now. So after about 5 years, and that is the current wait time, is 5 years. So in another year, it might be longer because the wait list continues to get longer. But after about 5 years, that's the wait time today. So right now, people are receiving a decision, a provisional decision, not the final decision, like a preliminary decision for people who applied in June of 2016. That is how long the wait is. So after about 5 years, if US Citizenship and Immigration Services looks at your application, it looks like you may qualify for the U visa, they will issue a provisional approval. This is called deferred action. It's not the same as DACA, which is for the Dreamers, Deferred Action for Childhood Arrivals. It's a different type of deferred action. And this gives you protection from deportation and a work permit, but this is not the U visa. You can renew that work permit while your deferred action status is valid, but we also refer to this as being on the wait list. So you apply, and then about 5 years later, you're given a formal spot on the wait list if it appears that you qualify for the U visa. If at that stage they're not sure if you qualify, they usually issue something that's called a request for additional information, a request for further information, a request for additional evidence, an RFE, request for evidence. And so if that happens to you, then you will have a time period, 30 days, 60 days, 80 days, whatever they give you to respond with additional evidence. And this is something we see come up sometimes if someone forgot something in their initial application packet, or they've had new criminal history come up or something like that. But if everything goes okay for the person that you're working with, then they will be given that deferred action status. And then an additional wait period kicks in. So there is actually no way to predict with any certainty when someone who applies for a U visa today will receive their U visa. The government only shares the data about when people are receiving their provisional approval, their deferred action status. So that is actually our only benchmark. So I could not tell one of my clients with any accuracy at all when they're going to receive a final decision in their case. So we are guessing a little bit here. But after about 10 or more years, that's what we're worried about the wait time being for someone applying today, they will receive a final decision, which would be the issuance of the actual U visa or a denial of their case. So why is there this wait list and this backlog? So USCIS can only approve 10,000 U visas every year for the entire country. And I don't know what the backlog is right now. I know it's over 100,000 pending applications. So if you do the math, like 10,000 a year, not everyone will be approved, but we're looking at a really significant wait period for these applications. So it can be really tricky. I mean, people have other things going on in their lives, right? They may move out of Texas or have more kids, things change, right? There's a lot going on in someone's life while this application is pending. So the name of the game is keeping in contact with your clients during this very long period of time. While the application is pending before they have deferred action status, that individual is undocumented. So they are at risk of being placed into removal proceedings or deportation proceedings. If they already have a removal order or deportation order in their name, they're at risk for being picked up by Immigration and Customs Enforcement and being deported. So having a pending application doesn't offer them protection. There are some small protections in place, like if they're picked up by Immigration and Customs Enforcement and they reveal that they're a U visa eligible individual or a U visa applicant, which they may or may have the wherewithal to do, right? But if they do reveal it, then they're given, I think it's a 72-hour period of time during which they're not going to be deported, and they can apply for a stay of deportation, like a pause. Criminal arrests and entering and leaving the United States will negatively affect the case. So the vast majority of my clients who apply for the U visa are undocumented, meaning they don't have a different visa, or they don't have a visitor visa or anything else. So they do remain in the United States during the entirety of this process. And leaving and entering the United States, the reason it could negatively affect the case is generally it requires additional violations of immigration law, but that won't be the case for everybody. But this is just, speaking in general. If the person you're working with is undocumented when they apply for the U visa, they remain undocumented during this time. It's okay if you have, generally speaking, to have multiple applications going at once. So someone can apply for the U visa at the same time they apply for deferred action for childhood arrivals, for example. So I have a lot of clients who are DACA recipients. They're part of the Dreamers, and they have a pending U visa application and they have DACA at the same time. Okay. So derivatives on the U visa. So the principal applicant is generally the victim of the crime. There are some exceptions where a bystander can apply, but generally speaking, the person who applies for the U visa, the quote unquote principal applicant, is the direct victim of the crime. So if the applicant is 21 years of age or older, they can apply for a spouse or an unmarried son or daughter under 21. If the U visa applicant is under 21 years of age, then they can apply for a spouse, unmarried sons or daughters under age 21, their parents, and an unmarried sibling under 18 years of age. The vast majority of my clients are 21 years or older, and the vast majority of the derivatives that I work on are actually children. So if you're working with an individual who has US citizen children, they don't need to be included in the U visa application, right? This is just for individuals that are also undocumented or who would also benefit from the non-immigrant U visa status. The derivative cannot be the perpetrator of the crime. So this comes up mainly when we're talking about family violence cases and would definitely be less relevant in a hate crime situation, but you never know, right? So if the perpetrator of the crime is a family member, they cannot be included as a derivative on the application. And so you'll see there's a lot of, under 21, under 18. So the ages of the principal applicant and derivative family members are frozen at the time the principal applicant files for their U visa application. So as you can imagine, with a 10-year waiting period, right, it's not very often that someone will remain under 21, for 10 years, right? You'd have to have really little kids for that. So the age is frozen, luckily, in time, so that people can benefit from that. So those are the family members that you can include on the application. And those family members do not necessarily have to be in the United States. There are ways to bring those family members to the United States after the EU visa is adjudicated through a process called consular processing. Okay. So that brings me to, I think, our Q&A session. One of the things I wanted to point out, though, is how to contact our office for services. So I put my contact information here if anyone here has any questions or wanted some additional information that we're not going to cover in the Q&A section. But if you know someone who needs to apply for services, this is our contact information. So we can be reached at 512-478-0546, extension 200. And we take applications for services over the phone Monday through Thursday, 9 a.m. to 12 p.m. And we do have access to interpretation in many, many different languages. So the person answering the phone will be bilingual in English and Spanish, but very luckily we have access to interpretation services via language line. So we're always, generally speaking, able to take an intake with someone and do a screening with someone in whatever language they're most comfortable with. And I think with that, we'll go to some questions.
Thank you very much for such a wonderful presentation. We have received a couple of questions. Do you mind if we'll go ahead and ask those questions now?
Sounds good.
Okay. So the first question goes like, can President Biden increase the yearly limit on U visa to help with the backlog?
No. So if we as a country want to increase the yearly limit on U visas, that would require Congress to act. So the 10,000 U visa cap per year is written in statute. So right. if that were to be changed, that would require Congress to act. And unfortunately, we have not had, the support for that to make that change, but it would make a huge difference just to increase it even, modestly, because this is one of the biggest wait times that we have in immigration law. So unfortunately, no, this could not be changed unilaterally by an administration to administration. It would require Congress to change the statute itself.
Thank you for answering that. Another question, how much does it cost to apply for the U visa?
So this depends a little bit on a couple different things. It depends if the individual needs to apply for a waiver. So the U visa application itself, applying just for the U visa, is free. The US government does not charge any money to apply for the U visa, which is fantastic. And that's in recognition of the trauma, based nature of it. However, if you're working with someone, and the vast majority of my clients are in this situation, who have at one point violated US immigration law, they would need to apply for a waiver for those past violations of US immigration law. The waiver is very expensive, and that costs $930. And that's the money paid to US Citizenship and Immigration Services for the application. There is a fee waiver available, a fee waiver for the waiver available. And so that would be available to individuals who are at 150% or below of the federal poverty guidelines, or who can show an economic, or financial necessity for the fee waiver. In my experience, it's generally just going to be people who are at the 150 or below of the federal poverty guidelines. And so if you've got a lot of family members applying with you, it can add up really quick. The work permit application costs $410, and there's also a fee waiver available for that one. So it could be as much as $1,340 for for each person applying. So if you don't qualify for the fee waiver, it can get pricey.
Okay, so we have another two questions that are kind of related. Can someone apply for the U visa from abroad? And can I certify for a victim who is no longer in the US?
Yes, so great question. The U visa is different than other types of immigration benefits in that there is flexibility where the victim is currently located. So yes, a principal applicant can have been a victim of a crime in the United States and then return abroad for whatever reason and apply for the U visa from abroad. And law enforcement can certify crimes, sign a certification, even if the individual is abroad. There's no problem with that at all. So when someone applies for the U visa from abroad, they will go through a different process than someone who applies from within the United States. They'll have an interview at a consulate and receive their visa at a consulate or embassy, and go through the process that way. So it's a little bit more complicated, a tiny bit more costly, but yes, a person can do it from outside of the United States, which allows a lot of flexibility with the U visa. And when you're certifying one of these, signing a U visa certification, you're not certifying that the person is in the United States, only that the crime itself occurred in the United States. So yes, there's a good deal of flexibility there. Someone could wait these 10 years if they wanted, in home country if that's what they decided they wanted to do, and then travel back to the United States once the U visa is approved.
I appreciate your patience. We have two more questions to go. How does USCIS consider criminal history when determining eligibility for a U visa?
Yeah, so they consider criminal history for two primary reasons. So the first is, like I mentioned, when you apply for the U visa, you have to show that you are admissible to the United States. And that's a legal term, meaning that you qualify with the admissibility laws of the United States. Those laws have to do with a variety of things. Anything from contagious diseases to ties to terrorism to, drug use, and criminal convictions is one of them. So if you have criminal history, especially criminal convictions, that can pose a problem for you, but it'll really depend on what the crime was and what the outcome was. Was it a conviction or was it something else? And unfortunately, in immigration law, many more things count as a conviction than they do in colloquial terms. So I won't get into the weeds there, but it'll depend on a couple things. So it's possible that criminal history could make you inadmissible to the United States, and that would require a waiver, like I talked about, to forgive that past violation of US immigration law. In addition, they consider criminal history for the discretionary analysis. So like I said, even if you meet all of the criteria for the U visa, there is a subjective judgment component to this where the agency looking at your case has to agree that you quote unquote deserve the U visa. So it's possible that your criminal history doesn't make you inadmissible to the United States, but it, according to the government, reflects so poorly on you, or you don't have enough evidence that you've changed or improved or whatever, it's a judgment call, right, on their part. But yeah, it can come into play in those two ways, and they do consider it very seriously.
Final question, can I still travel while my U visa is being processed?
This will really depend on your current situation. So there's no blanket answer to this. It will depend on the type of status that you have and the rules for that kind of status. So I always tell people, and especially my clients, before you leave the United States, talk to an immigration lawyer just to make sure that you're not running afoul of your current status or the U visa. But speaking generally, the U visa does not require you to be in the United States during the adjudication process.
That's it from Q&A, and now Fang, if you can please thank her.
Okay, I do have a question, Whitney. It might not be directly related to U visa, but I'm aware that some current situation a lot of immigrants are facing. Some friends from India, they somehow stuck in India into this catch-22 situation that during the COVID, the embassies and consulates are closed. so they cannot process or continue with their visa process, but they need that, that limbo situation that they're stuck in. Are you aware of any resources or organizations that they can seek help from?
Not off the top of my head. I don't have any clients in India. I have had a lot of clients in Mexico in that situation, but luckily that consulate reopened. And so I will look into it and get back to you, because no, I mean, it's a really difficult situation. I know they are doing some emergency processing. And so that would be a matter of getting in touch with the consulate to try and make that case for why emergency processing is needed. But I would have to look into it a little bit more to get a specific resource for that consulate, or well, there's more than one, but resources for India.
Right, appreciate it. Thank you, Whitney, for walking us through these resources that are very valuable for a lot of immigrants who are in need and in distress, right? And as we can see, there are a lot of scenarios that and the difficulties that immigrants are facing. So it's not hard to imagine how helpless they would feel in those situations already. And on top of that, they could be facing language barriers or discrimination, such as Asian hate. So we applaud the service that American Gateway has been providing to our Central Texas community since 1987. And people like Whitney, who not only care, but also dedicate their time and knowledge to make the difference through each individual's. I hope our members and our community will find Whitney's presentation and answers informative and helpful. If you have any further question on this topic or need any specific help, please feel free to reach out to Whitney and American Gateway directly. Moing, if you can display their contact information one more time, that will be very helpful. Or you can reach to Asian Chamber, reach to us at info@austinasianchamber.org. We're happy to relay your request. I also want to give a special thanks to our program and events coordinator, Moing, for putting this workshop together in a very short time while he hasn't been feeling very well during the past few days. So thank you very much for your hard work, Moing. Here we go. We see this is Whitney's contact information on the screen. So if you have any questions, follow-up questions, please reach out to Whitney and to American Gateway directly. Lastly, before we leave, I'd like to invite all of our audience to other events that our Asian Chamber is hosting and planning. First is the in-person member mixer. It's going to be our first in-person member mixer in a long time. So we're aiming at June 28th. The second one is our two major events from Asian Chamber. One is the Ovation, which is our annual gala on October 2nd, and our Fall Classic Golf Tournament, which is on October 18th. We also will organize and plan more workshops like this that our Asian business and our members, our community at large will find helpful. So please make sure that you check back on our website, subscribe to our newsletter, and follow us on our Facebook, Instagram, and LinkedIn to find out more details about those events. Thank you all again. Please enjoy the rest of your weekend. We look forward to seeing you all again soon.